Welcome to Torn, the only podcast committed to exposing the truth about the child welfare system and its devastating impact on families of color, told from the perspective of your hosts, Sonia Johnson and Classie Collinette, two defense attorneys who have over 15 years of experience working in the child welfare system.
Thanks for joining us today. We are joined today by our special guest, Professor Vivek Sankaran, and I will turn it over to my co-host, Sonia Johnson, to get us started.
Thanks, Classie. We are especially excited to have Professor Vivek here today. Tell you a little bit about Professor Vivek. He is the director of the Child Advocacy Law Center and the Child Welfare Appellate Clinic at the University of Michigan Law School. He has authored numerous articles about the beast we call the family regulation system, aka the child welfare system or the child protection system. He has written several pieces for the imprint, and one piece that he wrote was entitled Best Interest Standards is a Judicial False Idol. And we could think of no one better to talk to our listeners today than Vivek. Welcome, Vivek.
Yeah, thank you so much for having me. I'm eager to dig in and have this conversation.
Awesome, great. Is there anything in that background that you wanted to add to or tell our listeners about yourself that's not included in that background?
Well, not really. This is my almost 20th year doing work within the system, representing parents and kids and relatives. And every day that I enter court and I leave it, I just think that we're in this sort of strange paradox sometimes where we talk about things in court cases and court hearings, and we're in our little bubble. And I think this conversation is one of it when we think about like things like best interest. And then you leave the court system and you realize, wait a minute, like we all disagree all the time about what's best for our kids. It's what like makes parenting the hard and challenging and fun job that it is. And yet in court, we, in our world, we sort of think of these things as sort of objective criteria, that there's only one right answer. And so I'm just eager to launch into the conversation because I feel like the more I do this work, the more confused I leave every day. And so, I know the two of you probably feel the same way. And it's, I don't know what it is, but it's maybe perspective. And with that comes with a little bit of age that you kind of see how silly some of the things that we talk about are and act like there's only one path.
Well, and I'm glad that you said that. I know that I don't know why I was researching. I was probably doing some research on the term best interest, trying to get a handle on what it means, particularly in the context of, the work that we do, because in New Jersey, it's not defined anywhere in the child welfare system. So I think I was probably doing some research on the term, came across your article, and as I read every line of it, I was just excited. And I said, oh my God, this is exactly it. So before we dig any deeper, can you just explain for our listeners, what is the best interest standard? And I'm going to put in air quotes, in theory, in the context of child welfare.
So in the context of child welfare, there are a number of decisions, whether they are decisions about whether to separate a family, whether to place a kid in foster care, who that kid lives with, all the way to whether parental rights should be terminated. And at various stages, and it all depends on your state law, that you might see this phrase that a judge needs to do what's in the best interest of the child. And so often we just talk about it assuming that that's an obvious standard, that, oh yeah, the judge is going to act in the best interest of the child, as if there's one answer to that question. And in many states, as you point out, we don't define it. Michigan is another one of those states that doesn't have any standards or anything that explains what the best interest of the child means. And so what it means practically is, if you're a parent in the system, what judge you have or what caseworker you have who applies that standard is going to make a big, big, big difference. And because there's nothing that guides that human being. So if you draw me as your judge, I have in my head, based on my own biases of how I was raised and the community I live in and what my parents told me and what I've heard from, in the news and the media, all of these things that are like sort of populating my brain on what I think is best for a kid, which will be very different than what you think is best for a kid because you have a different set of life experiences. But the dangerous thing about child welfare is that we've made that into a standard where I get to judge other people's children based on my own perception of what's best for a kid. And
So,
that's the part that really scares me.
and so what you're saying is, and what you say in your article is, we've used the phrase, or we coin it, and we treat it as if the best interest standard is some legal standard, but in reality, it's not a standard at all.
Yes, that's absolutely right. We treat it and talk about it like it's almost like some sort of math equation where we're going to put a bunch of inputs in there and then it's going to spit out this answer that is objectively right. But like that's not how it works. There's no equation. It's not science. It's purely speculative and opinionated. I mean, I'll give you an example. Last 2 weeks ago, I was in front of an appellate judge of the Court of Appeals. My student was, where it's a case where the state wants to terminate my client's rights. He's a father incarcerated. Kid is living with a family friend. The child has a great relationship with her father and wants to continue that relationship. And so the judge denied the termination order, saying it is not in this child's best interest to terminate a relationship with somebody she wants to have a relationship with. So we get in front of the Court of Appeals, and the Court of Appeals judge is talking about, well, he just disagrees with what the trial court judge did and said, no, it is objectively best for the child to have permanency. Permanency means adoption. Adoption, it means termination. And therefore, the trial court made a mistake in determining what is best for a child. No, what really just happened is that the Court of Appeals judge just personally on a subjective basis simply disagrees with what the trial court determined in their subjective. But it's like we talk about it and the way that the opinion is written, we lost the case. And the way the opinion is written is as if it's like objectively true that there's only one right answer here about what's best for a child. And I guess I wrote that piece and I say this a lot, which is like, no, like we don't have the crystal ball. This is why I have 3 kids and who are all different human beings. And I wish I knew what was always best for them, but it's like, I'm guessing. My neighbors who are raising their kids are guessing too. We're doing our best, but we're guessing in different ways. And like, we'll figure out who's right. And I just worry in child welfare when you have the kind of the force of the state and coercion and termination and separation, when we inject these phrases that have to do with our own biases, there's a real danger. There's a real danger, right? I mean, what that tells me is the judge who said that, has been convinced from maybe his own life experiences that adoption is the best thing for kids, and that maybe he knows of adoptive parents who are friends and they've adopted kids and they turned out to be okay. And so in his mind, it's got to go in this lane. Whereas I can tell you lots of, kinship caregivers and grandparents who are raising kids in much more fluid, dynamic, like living arrangements where they haven't terminated the rights of the parents. And those have worked out fine. Right. So for you to say like one is like objectively better than the other is a scary thing for the law to allow.
I appreciate what you said so much. And as you were talking, I was thinking about a case. It's a case that I'm still working on. I represent a father of one of the girls. The main target of the litigation is mom. Mom's a Black woman who has some mental health issues, and throughout the FN litigation, she did not participate in any of the services. And so now we're in the termination of parental rights stage. And during one of the court proceedings, she came in, and I think the judge was explaining to her why we were proceeding with termination of parental rights. And he was saying, as the judge, it's my job to determine what's in the best interest of your children. And she said, how can you, determine what's in the best interest for my children, for the children that I pushed out of my body? How is it that you feel that you can do that? And, no one had a response for her, but, I was sitting there thinking she's absolutely right. How can you, who, sit and judge on a case, you hear periodically, you don't know the family, you don't know the children, you don't know the parent. How can you make a best interest ruling from that? And, that's the crux of what Classie and I wanted to talk about here today, because we're also talking about the racial inequity within the child welfare system. And so it seems to me that when you look at disproportionality within the child welfare system, one of the things, and let me just back up and say disproportionality, that there are a disproportionate number of Black and brown people within the child welfare system, you have to look at things like the best interest standard and really interrogate, really analyze what role does the best interest standard play in creating some of this disproportionality. Would you agree with that?
I do. Like, I think that, as a system, we have to go back and look at all of these places where people get to inject their own biases into any decision making because we have broad, vague standards. And I think this is an example of that, which is whenever we have a broad, even standard is strong, like you've suggested. I mean, a broad, whatever you want to call it, where someone doesn't have guidance and they get to decide whatever it is they want to decide. We're human beings. This is what we do. We bring every single one of our biases. But I think it's particularly dangerous when our systems are ruled primarily by white men or other folks who are affluent and that's how they got to the position of being a judge. And they have their worlds are so different than the worlds of our clients. And so for them to say that in their white upper middle class or wealthy backgrounds, that this is what's best, is bringing with it a whole set of kind of normative of how they've lived their lives, right. Which goes back to what your client says in some ways, which is like, but you don't know how other people live their lives. Right. And so there's rich cultures and communities that live lives so differently. And it's like the beauty of the world but for me to say, you got to go this way and not that, right? I mean, for me, I'm so stuck because I'm working a lot on termination of parental rights issues these days, but I'm just so stuck by this idea that we have now, as a child, whatever you want to call it, child welfare, family regulation system, decided that when a parent cannot care for a child themselves, that it is always best to sever and replace permanent, like that's the norm. I mean, that's what goes on in every across the country right now. Sure, there's exceptions and there's great lawyers challenging it, but that's the narrative we have to challenge. And it's befuddling to me because across the country, millions of children are living with family members in informal kinship, creative ways. We aren't going into all those houses saying, hey, grandma, you can't care for this kid unless you adopt. We have a rich culture. We have a rich sort of respect. But when you enter this door, the child welfare system all of a sudden is, well, you got to adopt then. You got to adopt, you got to terminate. And I'm tired of practicing in a system where I see too many cases where the kid has a close, loving relationship with their parent, and yet we destroy it. And that to me is befuddling. And we do it in the guise of this standard, right? I have a client right now where the client was addicted to drugs, could not care for the child, but boy, he visited the kid every day at grandma's house, helped bring the kid to school, and did all the things that we'd want him to do. And yet, because he couldn't care for the child on his own, they moved to termination. And on the day of the termination decision, the trial court judge says to the dad, I hope you can still see your child every day, even after this decision. What are we doing? Yeah. Right? What are we doing? But then, but that's the narrative that we've created. And I think part of the work, and this is why I love this conversation, is we can change laws all we want, but if we don't change how people view our families and how we think about these issues, then we're not going to make any progress, because it's too kind of in the values that our decision makers have right now.
Well, I think that's also why we, Classie and I, decided to do this podcast, because we think it is important to completely reimagine the child welfare system that we have. Just what you spoke about, that it is the default, that if you're looking at a permanency option for a child, that the presumption is that it's always in the best interest to terminate the parent-child relationship and then find permanency, or find some other permanency, as opposed to, I think, if we took a step back, if we imagine this, maintaining those family bonds is probably, and there's probably some clinical data to support this. I believe that you indicate that in another article that you just recently wrote, that the clinical data supports that it's in the best interest of the child to retain those family bonds and those family connections. So if we were really about, doing what's in the best interest of the child, we would not default to termination.
No, I love that. I mean, what if we, now that we're reimagining, what if we built a system around relationships and said to, when a kid can't go back home, let's ask ourselves, like, well, what relationships matter to this kid? And then let's figure out, we're creative people, let's figure out how the law can protect all of these relationships that matter to this kid. And what if we, it's crazy to think that in Michigan, at least, and in many jurisdictions, we start a case, first court hearing, telling a parent, if you don't do these things, you might end up having your rights terminated. And I guess, and I get why we say, and then we expect that parent to then partner with this system and engage with it, right? Could you imagine that, in a criminal case or some other, I don't know the analogy, how we want you to work with us for the next, 12 months, but that gun is always hanging over their head.
Right.
And right. And in my mind, what if we reimagined a system where TPR was just taken off the table for 95% of cases? And that we told families that we are not going to permanently destroy your relationship with your child. Your child may not go back home, but we're not going to create a situation where you'll never have a right to see your child again. If we did that in our cases, perhaps we'd have a different relationship with families in the system. Perhaps we might inch a little bit closer to that collaborative-ish public health model that we all talk about, but our actions don't align with our values, because then we say these things, and then the first time a parent sets foot in court, we're like, hey, we might destroy your rights permanently, just so you know. Now come work with us.
Come work with us, right? And oh, by the way, you've got 12 months to get it done, and we don't care.
And we're not going to offer you services in those 12 months that will actually address your issues. I'm glad that you talked about, in the beginning, you're like child welfare or family regulation or whatever we call this system. We can't call our system a child welfare system when we can't address housing, employment, food insecurity,
exactly,
lead in the house, crappy schools. We don't do it. We're powerless to address these things that have to do with child welfare.
I have another story. So I had a case, and it involved a father who had an alcohol problem and a mother that, had some mental health issues, but it was really more that she didn't know how to deal with dad's substance abuse. They got the counseling. Dad was clean for over a year, testing regularly, always clean. I was arguing after about a year into this, and with dad really testing clean and doing great, and mom had followed through on all of her services. All the service providers had indicated that they had done great and that there was really nothing left to be done. I could not get the division to agree to dismiss the case because the DAG and the law guardian wanted the oldest child, who was, I think, 3, to go to daycare.
Yep.
And this was a Guatemalan family that had moved to the United States. And I was trying to explain from either a cultural standpoint or just a financial standpoint that they may not want to do that. And now that the safety issue has been addressed, that the case really needs to be dismissed and allow them to go off to be a family. But the judge essentially sided with the state and said that it was in the best interest of this family for this child to go to daycare, and would not dismiss the case until the parents registered the child in the daycare program. And I made a big stink on the record. I said, with the court is ordering something without understanding or appreciating the impact financially to this family, whether or not they can physically get to the daycare, or whether or not culturally that's something that they want to do, because their culture may be that for the next, until the child is, school age, that their culture is one in which the child would stay home with mom and dad and learn from mom and dad. But we butted heads with this best interest standard that is no standard at all. And I said, if the court is really, if the division is really concerned about families, look at the community that we're in. And just what you said, Professor, the poor schools, the inadequate housing, it's a food desert, so to tell folks that you need to do this without looking at the real realities that they're living in, it was just absurd to me.
No, such a great example of like the hypocrisy of our system, where on one level, judges are so willing to point out things they want families to do, which may or may not, be something that the families themselves want to do, or maybe, or and it doesn't respect the judgment of families about what they think is best for their own kids. But how silent they are about the systemic things, the harms,
right,
that we just ignore them. We almost seem powerless, right? What if judges spend as much time yelling at the state for not providing free daycare for families, and for not providing free mental health services and all that stuff? But it's just the frame and the narrative that we've embraced, that it's almost we're going to blame families and excuse the government for the society we've created.
Vivek, just want to dig a little bit deeper into some information that the Children's Bureau shared in a publication. So the Children's Bureau found that only 22 states and the District of Columbia list in their statutes specific factors that courts should consider in making best interest determinations. Your state, the state in which you live and work in, Michigan, lists 12 factors to be considered. Do you think having certain factors that a court must consider in making a best interest determination fixes the problem you raised? And if you could tell us why or why not.
Yeah, and Classie, a great question. Just to clarify, in Michigan, when it comes to child protective cases, we actually don't have any factors. The factors that exist are in child custody cases, where it's a parent versus parent private dispute. I think so. If we're going to have a best interest standard at all, I think certainly forcing judges to consider some things that might matter to a child is a good thing. So, for example, and to state it on the record. So, for example, what does the kid want? Does the kid want to have a relationship with their parents, and in what way? What does the family want? Right? Is there a way to sort of capture and let the family, especially, about a third of all adoptions out of foster care in the United States are done with kids living with relatives. And I just worry that we don't even hear their voices in these proceedings, right? What if they don't want to terminate the rights of parents? And so I think like factors like that. I also think like the things like the child's prospects of being adopted or whatever it might be something that's worth considering in the context that we have so many kids who are aging out of foster care, and we still deem that it's best for them to have their rights to their parents terminated. And the question is why do we sever when we're not even replacing in any way that relationship? So I think something, but for me, the relationship between anything that would force a judge to capture the relationship between a child and the parent, and then have to explain on the record why it is still good to terminate something that is meaningful to a child, is something that would bring the law I think in a positive direction. And so I know, the next couple of questions you had relate to termination of parental rights. And one of my things is, I think both as a matter of constitutional law, but also best interest, is that judges, when such a relationship exists, they should have to explain why the other alternatives are insufficient.
Right.
Like we have a great, guardianship statute in Michigan, a juvenile guardianship statute that doesn't require termination. is intended to be long-term. I mean, the statute says it's intended to be permanent. And so not something that should be changed is meant to be changed all the time, but one that recognizes that kids can have relationships with multiple people. And again, this is where like culture and narratives play such a big role. Like our judges just ignore it. I mean, they just don't think it's as permanent as adoption. But like I am still perplexed on what basis. If I had my my magic wand, judges would have to explain in cases where kids couldn't go home why that wasn't a sufficient outcome. Right? It's subsidized, but it still allows connection between family members. I bet you that and there's some research on this, that it would shorten lengths of stay in foster care if guardianship was more widely available. Because in a lot of, honestly, a lot of my parents that I represent know that they can't care for their child, but they don't want their rights terminated. If there's another option that we seriously considered with family, they would say, let's just do that. I'm fine with it, as long as it leaves open possibilities and hope that if I change and if I overcome my addiction, if I overcome my mental health issues, if I get my life together, that door is still open for me one day. If I could tell my clients that, many of them wouldn't go through this, the ordeal of trying to do this right now. But the problem with our termination obsessed world is, if I say these are the options, they're gonna say, well, like, fight like hell. Let's trial. And then like what I usually get involved in appeals, and like let's appeal it up the water. So I got cases now where the termination happened like 2.5 or 3 years ago, and we're just battling on appeal, and we're just going at it because my clients aren't going to give up, nor should they, because this is we don't have a way of getting this back once it's finalized.
I think the thing that's so funny is, to hear that, you've got cases that are, 2-3 years old on appeal, because we're having the same issue, is the argument for, whenever we're at a TPR litigation, is like the child needs permanency. The child needs permanency. As if, as you said, these other options don't provide permanency. But I always say, well, TPR is not necessarily permanency, because if there are issues to be appealed, then the child has to wait through the appeal process, and so you don't have permanency.
Totally agree. Yeah, if we wanted children to get permanency more quickly, we would adopt these less adversarial possibilities and work with families to craft a solution that doesn't shame them. I mean, that's the point. We haven't talked much about the punitive shaming nature of TPR, but it's destructive on clients because it's a judgment that we're making, that they're not just bad parents, that they're horrible human beings, is how they feel. It's how, right? I mean, and I know, Sonia, you both have represented clients in these positions, and it's not just about losing your children. It's about that feeling of how you feel when you have a judge telling you this.
The first prong in our statute is that the parent is unfit. Yeah. That's the first prong. So, it's immediately confrontational. And you, as you said, the shame of it all, that, I can't parent my child, as opposed to a process that says, hey, listen, I'm not there yet. I need some support. I do love my child. I do want to maintain a relationship with my child. Let's find a way that, I can support my child and still remain in my child's life and still maintain my dignity as a parent. I absolutely think that, that is the better course. I'm struck, though, as I indicated, you did write another article recently that talked about the case against termination, a constitutional case against termination. But also, though, it seems to me we all recognize that the right to parent is a fundamental right. And just to take it back to best interest for a second. So we've established that it's no legal standard at all. So how is it we have allowed within child welfare judges and child protective services to push this standard on us when we're talking about a fundamental constitutional right? It seems to me that that's unconstitutional, and sort of, marry that or tie that to the argument that you made about TPR being unconstitutional.
Yeah,
So,
I don't disagree with you. I think that sometimes what we see in court every day is a world that has been created outside of any sort of constitutional norm, and advocates and people who are in these systems have often, they enter it, so they inherit whatever the world is around them, and they don't and it's hard to push back for a number of different reasons. But you're absolutely right that we have a system where parents have a fundamental liberty interest. We have case law from across the country that says that when you want to permanently strip that away, the government has to look for other options before it does it. And what you have in child welfare, though, in our system is the opposite, which is when a parent, can't do it themselves, and the government looks for the most severe option,
right,
and is rewarded financially for it.
right,
Right. And as lawyers, when we say, hey, wait a minute, there's other options out there, judges will say, no, that's not best for children, and almost, use that as a sword. And I think what we're trying to do in some of our writing and litigation is to get courts to almost focus the system within a constitutional realm. And so it's what I tell my students, though. We make these crazy arguments. We're going to lose many, many, many arguments over the next, and we have lost many of arguments, but like all it takes is one good judicial decision in a state to change the culture of the state. And if we can get, so I have a series of cases right now pending at our highest court, and I'm just hoping that in one of them, they'll start acknowledging that there's a constitutional framework that needs to be applied that we have been overlooking for years, because it's all, it's all, incremental progress is how I think about it, right? Like this isn't going to happen in my lifetime, but if I can play some role in inching it a little bit closer to the world that we want, that'll be kind of the mark of a successful career as far as I'm concerned. Like that's all we can do.
Well, as I have a TPR case coming up, it's scheduled for December. I'm going to try and stall as long as I can, but I will make that argument that it is unconstitutional to move to TPR when there are other options out there. And in addition, my client would have rights under ADA, and that's another area where the state court, the child welfare court, does not really enforce federal rights under ADA's American Disability Act. And I've made the argument in court and, it goes in one ear out the other, but I'm going to add to the ADA argument, the termination of parental rights is unconstitutional argument, and just keep hammering away at that.
I love that. I would, of all places in the country, a colleague of mine and I have discovered that there's a string of cases in Alabama where their appellate courts have just done a phenomenal job reversing terminations of parental rights for constitutional reasons, because the state didn't look at other alternatives. And so that's the next kind of article that we're working on, is to show the country sort of how this law developed and lessons learned, because it's pretty amazing. And one of the things I enjoy about the work in this field is, it's complicated politically, and you can actually find some allies on the right who are more limited government, libertarian, government stay out of my house, overreaching, that I suspect there's a little bit of that might be going on over there.
I didn't think of it that way, but I will certainly start looking across the aisle for those allies.
I'm trying to keep hopeful.
I like what you said, that judges need to be focused on relationships, right? And if our case is just focused on relationships, we might have far better outcomes for families. One thing that has come up in some of my cases in the past is children who eventually age out of the foster care system. They end up going right back home to their birth families anyway. And if judges had this in their mind at the onset of a case, I think that is also one key piece of information that could also change their view and quite frankly, even some of their rulings. So I'm curious to get, your insight with respect to that, and how you think that key piece of information, i.e. children going right back to their birth families anyway, how would that influence judges' decisions at the beginning of a case?
Yeah, I'm so glad you mentioned that, Classie. Like, I think even in the word permanency, we've invented this fiction that like life is linear and clear cut, and we're going to end this relationship and replace it, and we're done. Like, but here's the reality: like, kids don't act like that, and they don't think like that. And what we may declare permanency, like, it's messy, and like they might dislike their parent now, but in 3 years, they're leaning on their parent for support. And I think as a system, this is where I think it goes to values and culture again. We gotta learn from what our youth are telling us or are showing us through their actions. And they're showing us that, like, to almost embrace the messiness of what we all know that life is, and not foreclose options. That what might be good today might be different tomorrow. And and this is why, like, look at what we do in custody cases between parents. We don't go around terminating. Like, when a parent is substandard, we grant legal custody and physical custody to one parent, but we don't say to the other parent, "You're done. Like, that's it. Get out."
Right.
No,
Right.
we've done the opposite,
Right.
which is a presumption almost that you have for joint legal custody, even when a parent is really bad.
Right.
And so then because we think that, like, life changes, people change, human beings change, right? I'm not the same person I was 5-10 years ago in many ways. And yet here we foreclose that, right? And this is why, like, people ask me a lot about like reinstatement of parental rights statutes and whether I like them or not. And my response is almost always, they're fine, but why are we trying to, if we know something is broken and we're unnecessarily terminating something, like, then why don't we just stop it from happening in the first place?
Right.
Right. Like,
Exactly.
and your example is great. Like, why don't we listen more to what children are telling us and families are telling us about what they want for their people? And so, no, I love the point that you make, that it's yet one more example that relationships are so critical for our kids.
Thank you for that. Thank you. We try to end each episode with tips for parents who are engaged in the child welfare system and tips for advocates. And so, Vivek, do you have any tips in and around the best interest standard, how perhaps to address it or attack it, or any other tips that you'd like to share?
Yeah, so I think for advocates, it would be, raise the constitutional framework issue over and over and over again. For those who want a sample brief, just reach out to me. I have a former student of mine wrote something up. I'm always happy to share resources. And so, I think we as a field, we're going to lose a lot, but like, that's part of being in a system where we have to challenge oppressive sort of institutions. Is we raise it and lose and raise it again, and eventually, we'll start getting some judge to see things differently, and we'll make progress. For parents, it's really, for me, the advice would be to think about how to create evidence to get judges to see you differently. And that's hard, and it's an unfair ask, right? Because and I get it, but we're also in part of the struggle that I often face in a lot of different things is, on one hand, it's an unfair ask because that's not the world they should be in.
Right.
On the flip side, it's the world, like, we live in an unjust world, and people carry different burdens because of it. And unfortunately for our parents and our child welfare system, they can't opt out. I mean, their kids are in it. And so, like, part of it is like figuring out, what do I do? How do I like, and so, like, things like, if a kid's living with a relative who does not support termination, getting them to be a witness for you in court and saying, and getting them to say that on the record, or getting them to call your lawyer, getting copies of documents from your providers or visitation supervisors, or stuff that lawyers should be doing as well. But like, I think families should take some ownership over it if they can, to create the counter narrative to what the judge is thinking is good for a kid. So I think stuff like that is what I would think about. But really, for me, we just have to keep talking about it. And there are a lot of good thinkers out there who are interested in a world where TPR is minimized or eliminated. And so just continuing to push courts and others, agency directors, just to see things differently, because sometimes that's the hardest thing, is just to get someone to ask a different question, because they've been asking the same question over and over and over again for the last like a million years. And so they think you're crazy when you suggest something. And right. And then once you do, like, oh yeah, we could do it that way. It's hard. We all do it. We all do it in our own life. I do it in my own life every day, because I'm a creature of habit. And so someone will say, well, why don't you do that? Like, why don't you walk your dog at 10 instead of 8:30? And I'm like, well, why would I do that? I've been doing it at 8:30 for the last 5 years. I'm going to do it at 8:30. And I think that like caseworkers who are well-intentioned just don't think about it, because they're just like, they're just going through the motions every day, and every day is the same as the day before.
I love that, because I was thinking, how do parents challenge the narrative or provide additional, something other than what the narrative is, right? So we're looking at best interest. Well, so often courts act as if the child did not have a life prior to, being removed. So, if you're removing my child from my home, you need to know that my child was in this school, doing well, had these connections, was involved with these parties, went to, camp over here, went to dance program over here, have my child has relationships with these people over here. And that's, putting the burden and onus, unfortunately, like you said, on parents who are involved in this system. But we have to find ways to counter the narrative, as though, the system is saving this child from something, as opposed to, the system is taking this child away from this other good, wonderful connections and experience. So I love that. Thank you for that, Vivek.
This has been great.
I love this. I feel like we could talk for hours. I love the conversation, and I love the work the two of you are doing, and just I feel like we're partners in this pursuit. And so just keep it up. And I think one day when we look back, like I bet you 10 years we'll look back at this conversation and realize that we've made some progress towards creating this world.
I hope so, Vivek. I really do. Yes. And I appreciate you so much for taking the time to speak with us and speak with our listeners today. And keep writing, because I love it. I found you on Imprint, and I was just like, absolutely. And I actually just downloaded an article that you wrote a while back, Parents Patre Run Amok, the child welfare disregard for the constitutional right.
Theme. It's like
I see it. I love it.
Well, I'll end on this. I promised a client of mine, we just lost a case at the Michigan Supreme Court, which means that she will never get to be a parent to her kid again. And amidst the tears that we were sharing on the phone, because the road has ended for her appeals, I said that I promised that she would, when I write a book one day, her story is going to be right center it, because she was a parent because she kept on saying, I don't want my suffering to be for nothing. And I'm like, all right, this is it. This is my commitment to you, that one day, I don't know when, but one day, there's just too many stories, and I think part of it is people have to hear them.
Yeah.
And so you all keep doing your podcast, keep sharing the work, and I'm sure we will cross paths sometime soon.
Thank you so much.
Yes. Thanks, Vivek.
The opinions and views expressed on this podcast are those of its hosts and guests and represent our own lived experience. The views and opinions expressed do not reflect those of any agency or organization with which we may be associated.